Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We especially welcome those who are joining us on our heritage.org website as well as C-SPAN TV. We would remind everyone in-house, please check cell phones that they've been muted as a courtesy to our speakers. And for those watching online, we're always welcome to send questions or comments to us, simply emailing speaker@heritage.org. We will, of course, post the program on the Heritage homepage following today's presentation for your reference in the future. Hosting our program is Roger Severino. He is director of our Richard and Helen DeVos Center for Religion and Civil Society. He earned a JD from Harvard Law School and an MS in Public Policy from Carnegie Mellon. He is an alumnus of the Becket Fund for Religious Liberty and has also most recently served in the Civil Rights Division of the U.S. Department of Justice. Please join me in welcoming Roger Severino. Roger.
Thanks, John. So glad to be here. So glad to see such a large turnout for a discussion of what may be the defining issue of our generation, the future of marriage, religious liberty, and the law. As you know, the Supreme Court in Obergefell versus Hodges recently issued its decision. It was a monumental one. It has deep implications for the future of our society. We've had a significant setback. All Americans who believe in the Constitution, limited government, democratic control, and marriage of the union of one man and one woman should pay close attention. The U.S. Supreme Court got it wrong. Today we have a distinguished panel to give us perspective and help inform our responses to this decision. Please hold your applause until the end of the introduction. In the middle we have Mr. Gene Scher, who's a Washington, D.C. based attorney who specializes in constitutional and appellate litigation. He previously served as associate counsel to the president and as law clerk to Justice Antonin Scalia. He's argued and won dozens of cases in a variety of forums, including the U.S. Supreme Court, where he argued 6 cases, every federal circuit, and numerous state and appellate courts. He's a graduate of BYU, earned a JD from Yale Law School, and holds a master's degree in economics from Yale University. Dr. Ryan Anderson, at the end, researches and writes about marriage and religious liberty at the William E. Simon and is a William E. Simon Senior Research Fellow in American Principles and Public Policy at the Heritage Foundation. He focuses on justice and moral principles in economic thought, healthcare, and education, and has expertise in bioethics and natural law theory. Ryan filed an amicus brief in the Obergefell case with Justice Clarence Thomas citing him in dissent. The book, which he co-authored with Professor Robbie George and Sharif Girgis, is What is Marriage, Man and Woman, a Defense, which was cited twice by Justice Samuel Alito in the Federal Defense of Marriage Act case. Ryan is the author of a forthcoming book, Truth Overruled, The Future of Marriage and Religious Liberty, which is available for pre-order on Amazon and will ship in a few weeks. Ryan received his bachelor's from Princeton University, graduating Phi Beta Kappa and magna cum laude. He earned his doctorate in political philosophy from the University of Notre Dame, where he also received his master's degree. Carrie Severino is Chief Counsel and Policy Director of the Judicial Crisis Network. She has written and spoken on a wide range of judicial issues with focus on constitutional limits on government, the federal nomination process, and state judicial selection. She has filed briefs in numerous high-profile Supreme Court cases, has testified before Congress, and is a regular contributor to the Bench Memos blog on National Review Online. If you have any interest in the course, you have probably read her materials or seen her on TV. Carrie was previously a law clerk to the U.S. Supreme Court Justice Clarence Thomas and to Judge David B. Sentell on the U.S. District Court of Appeals for the D.C. Circuit. She's a graduate of Harvard Law School cum laude, of Duke University, holds a master's degree in linguistics from Michigan State University, and she's also married to the luckiest man in the world, me. Please join me in welcoming our panelists. So we've read this giant decision over 100 pages with dissents, and I'm sure there are many takeaways, but I want to focus on 3, and I think it might split up among the expertise of the panelists. So what are the big takeaways that you folks saw in terms of the law, religious liberty, and marriage culture? So if you could start, probably Carrie with the first one.
Sure. Thanks for being here. First of all, it's nice to be on a panel where I don't have to tell the introducer how to pronounce my last name. So I'll start by talking about basically what the legal basis of the decision is, and then we can talk about some of how it plays out in terms of religious freedom in the culture as well. Justice Kennedy's decision, he wrote for a 5-4 majority, as of course you all know, was based fundamentally on the idea of substantive due process and the fundamental right to marry. Now, I actually would agree with him that there is a fundamental right to marry. It's something that has been recognized by a lot of cases, and most famously in Loving versus Virginia, where anti-miscegenation laws of the state of Virginia were struck down. However, Justice Kennedy does get it wrong because as he actually acknowledges, all of the court's cases that talk about a fundamental right to marriage take as a presupposition that marriage means a union of a man and a woman. And it's dangerous when we redefine the terms of the act that we're actually dealing with, because you can easily shift the meaning. So, for example, if we were to take we have a freedom of speech, and we define speech to mean something else, and suddenly we have freedom to something else. All of these terms have to carry actual content. So the challenge here is that he redefined the term marriage in the process of attempting to uphold the fundamental right to marry. The way he did so is by looking at some of the cases the court has decided previously and intuiting 4 principles from those cases that he viewed as central to this institution of marriage. One is that it was an expression of individual autonomy through personal choice. One is that it was a unique 2-person union that gave particular importance to individuals. The third was that it safeguards children and families, and particularly draws on the rights of child rearing, procreation, and education. And then the fourth is that it forms a keystone of our social order. Now, there are undeniably themes of all of these in the previous Supreme Court literature. However, Justice Kennedy seems to completely cherry-picked which principles he looked at, with the one goal in mind of coming to his conclusion, which is, look, all of these central features of the fundamental right to marry, doesn't matter if it's a man or a woman versus a same-sex couple, and therefore the fundamental right to marry isn't really defined by that. But unfortunately, when you assume, by assuming the conclusion already, he chose the principles that would support it. It's interesting also to see that he didn't actually, in my opinion, choose those principles to overlap perfectly well, because he does cite to the rights of child rearing, procreation, education, and it is simply difficult to understand how a particular right to procreation has nothing to do with an opposite sex union, when that's obviously how procreation happens. So there's a real problem with Justice Kennedy's kind of bait and switch on this. Yeah, he takes things that are really there as part of the definition of marriage, isolates only those, and not even only those, but mostly only those that don't have an obvious connection to the opposite sex couple union, and then says, well, look, marriage isn't really about a male-female union that's procreative. It's really just about 2 people having a unitive relationship. Finally, additionally, after deciding under the Due Process Clause that this is a fundamental right that is being denied, he then claims that the Equal Protection Clause is also implicated. It's true that the court's discussion of the Equal Protection Clause and due process liberties are very intertwined and can be confusing at times, but he didn't follow a traditional Equal Protection Clause analysis, which is to say, what is the level of scrutiny under the Equal Protection Clause? We know that when we look at traditional equal protection law, there's different levels of scrutiny we can give. Certain distinctions you're making require strict scrutiny, so it's very hard for a government to make any distinctions, for example, on the basis of race. Others have intermediate scrutiny. For example, on the basis of sex, there's certain things where there are sexual differences that the government can take into account, but there are others they can't. He didn't talk at all about what level of scrutiny we should be giving, so that, I think, is a line of cases we're going to see coming out of this going forward. And then to talk quickly, there were 4 major dissents in this case. There were 4 dissenters, and there were 4 dissents that were written, and they all sort of tended to join each other's dissents in the process. In large part, all the dissents touched upon a few major themes. One is the decision simply as a legal matter is not correct. That whatever your policy views on the issue, and I actually would wager that even among the dissenters there may be different policy views on whether or not they would vote in a referendum or vote for a politician who would say, I want to create same-sex marriage. I think they may come out differently on that, but I think they all agree that as a legal matter, the Constitution is not where that happens. The Constitution is completely agnostic as to how marriage is defined, and if anything, the Windsor case that happened a couple of years ago that Justice Kennedy wrote got it right on this point, that the states have traditionally defined marriage law, and, and certainly for state purposes, states should be able to do so. So that's one feature of the dissents. Another is talking about concerns about the democratic process, concerns about the way that the decision was reached and how that undermines the ability to have this debate in the public sphere. So we were all talking about this issue. There were a lot of referenda. There were state laws. There were constitutional amendments proposed on both directions in different states, and that has been cut off by this decision. Justice Kennedy alluded to that. He basically said, well, look, there's all sorts of amicus briefs. There's been a lot of, we've had this discussion. We're done. We're good enough. Time's up, and now we're going to make the call. But I think the dissenters would have said the court doesn't get to be the one that makes that call of, now you've had enough talking. When it's an issue that the Constitution leaves open, even if you feel like you're sick of hearing the debate, you don't get to cut it off. And then finally, and I think some other people of the panelists are going to talk about this, all of the dissenters really highlighted their concerns about religious freedom coming out of the decision. Justice Kennedy's decision did allude to the fact that, as the Solicitor General really said, this is going to be an issue going forward, but it's taking things out of the democratic process does mean that now our backstop is the courts. We have our First Amendment protections, but it's the courts that are going to do it. And to highlight, since Justice Thomas is sort of my favorite justice on the court for reasons that should be obvious, having worked for him, he's a wonderful man, as well as a very principled judge. I think he pointed out really two important errors in the decision. There are two inversions that they make. First, it assumes that dignity is something that's confirmed, that's conferred by the government. But in fact, if we look at our Declaration of Independence and the Constitution itself, dignity is presumed to be innate. To either come from our Creator, if one goes to the Declaration of Independence, or even if one is agnostic, to be innate in the human person and not something that the government can confer or deny someone. So even for example, while there was slavery in this country, that doesn't mean that those who were enslaved lacked dignity because the government was failing to recognize their dignity. Furthermore, he pointed out, and some of the other dissents did this as well, the inversion of liberty, that our nation and really the Anglo-American legal tradition has a history of liberty being freedom from coercion, not liberty being a government grant of benefits. And that was what happened in this case, the idea that the government conferring the benefit of marriage and the associated benefits is actually increasing people's liberty. So I'll hand it on back to Roger to bring the next one.
So you mentioned the dissents. There were 4, Jean, that actually wrote and spoke on religious liberty. First, what do you think about the extent of the dissents being 4 of them, and specifically on the religious liberty topic? How much weight is to be given to those arguments compared to what Justice Kennedy had to say about it?
Well, I think what's interesting to me about the decision, including both the majority and the dissent, is the extent of the recognition that there really is a conflict between same-sex marriage or institutionalized same-sex marriage and religious liberty. And you might wonder, why is that? And what a lot of people don't seem to recognize or remember is that all 3 of the major Abrahamic religions, Judaism, Christianity, and Islam, and indeed all other major world religions have for millennia, to use Justice Kennedy's word, for millennia they have taught that a man-woman union is not just an incidental feature of marriage, but it's central to marriage. And that, of course, is fundamentally different from some religious teachings about interracial marriage, which, of course, was the issue in the Loving versus Virginia case. I spent my high school years in the South, and I never heard of any religion that viewed racial homogeneity as a central defining feature of marriage. There were some people who thought that that was preferable for sometimes religious reasons, but I'm not aware that any small or large religious body has ever taught that racial homogeneity is a central defining feature of marriage. And so that's fundamentally different from the situation that we have with respect to same-sex marriage. And yeah, there are a few religious groups that have broken from that tradition, but if you look at the number of people that claim to adhere to those religions, it's a pretty minuscule percentage of the population of all believers. And so there is this enormous conflict, or at least enormous potential for conflict between same-sex marriage in general and the decision in Obergefell specifically, and religious freedom. And that may well be one reason that Justice Kennedy sort of went out of his way in numerous places in his opinion to try to suggest respect for the religious viewpoint on this issue. And in fact, I think of all the opinions that have been written in the course of this litigation over the last couple of years that have ruled in favor of same-sex marriage, Justice Kennedy's opinion is probably the most respectful of religion. And so those of us who care about religious liberty can be grateful for that. And just for example, Justice Kennedy did not rule that traditional marriage laws were based on animus or hostility or bigotry towards gays and lesbians, and there were a number of people who were urging the court to rule that way. He did not rule that traditional marriage laws are irrational, as Judge Posner, who used to be considered a conservative judge, ruled for the Seventh Circuit not long ago. Either of those rulings would have been taken as a holding that opposition to same-sex marriage is in effect a manifestation of religious or other bigotry against gays and lesbians, rather than being an intellectually defensible position. Justice Kennedy also implicitly rejected the U.S. Justice Department's position that sexual orientation is a suspect class and therefore entitled to special rights in constitutional litigation. And that kind of a ruling would have created a whole host of religious liberty problems outside of the marriage context. So, those of us who care about religious liberty can be grateful that Justice Kennedy's opinion dodged some big bullets. But the opinion unintentionally, I think, launched a number of grenades that are still in the air. And as I've thought about it, I've identified really 12 concrete threats to religious liberty, what I call the dirty dozen. And in the very short time that we have, I'm not going to try to explain them in detail, but let me at least list them, and then maybe we can talk about them later. One, of course, is the issue that was raised by Justice Alito at the oral argument about tax-exempt status. And you probably remember that exchange between Justice Alito and the Solicitor General, Don Barilli. Justice Alito asked him, well, if we rule in favor of same-sex marriage, doesn't that create a risk that religious organizations that believe in the traditional view of marriage would have their tax exemptions revoked? And Mr. Barilli, after initially appearing like he was going to try to dismiss the question, decided that he needed to be frank and honest, and he said, "I can't deny, Justice Alito, that's going to be an issue. Yes, it's going to be an issue." And so that's certainly and it is going to be an issue, I suspect. And the fact that the Obama administration has not done anything to walk back from what Mr. Barilli said at the oral argument suggests to me that there may well be people within the Obama administration who are actually planning to issue a regulation or some kind of a decision that would in fact deny tax exemptions to at least some religious institutions that choose to adhere to the traditional understanding of marriage. And my first 6 examples are in the area of what I call institutional religious freedom or religious liberty. That is the ability of religious institutions to carry out their self-defined religious missions. The other 6 are in the category of individual religious freedom. So the second one is an issue that Justice Scalia raised at oral argument, which is a church's authority to have marriages performed by its pastors recognized by the state, recognized by civil government. And of course, that's the standard practice now. Any minister who marries people in the United States, that marriage is recognized not only for religious purposes, but for legal purposes as well. And Justice Scalia raised the question, well, if we rule that same-sex marriage is required by the Constitution, isn't that going to set up a situation where where churches that don't believe that a same-sex marriage can be religiously legitimate, aren't they going to be denied the ability to marry people and have those marriages recognized by the state? Aren't they going to be denied the ability to marry anybody and have those marriages recognized by the state? That, I think, is likely to be a serious issue over time. Chief Justice Roberts, during the oral argument and then in his dissent, raised the issue of religious school housing policies. As you probably know, most religious colleges in the country have policies that they have special housing for married students, but in order to use that married student housing, you have to be married in accordance with the beliefs of that particular religious college. And the Chief Justice raised the question, well, aren't those kinds of policies going to be at least cast into doubt if we rule in favor of same-sex marriage? And that's another serious issue. An even scarier prospect from my standpoint is the licensing area, which of course is very important in higher education. Religious colleges, like every other college, they depend on their ability to get accredited by a wide variety of accreditors in order for their students to be able to get federal funding, and in order for their students to be able to get jobs in a lot of professions. And so if same-sex marriage is really the law of the land, if it's really constitutionally required, isn't there a risk that accrediting bodies are going to start pressuring religious colleges to recognize same-sex marriages for all purposes on their campuses as a condition of accreditation? We've seen a similar issue with regard to other religious organizations like Catholic Charities that in some circumstances need licenses to carry on their works. For example, licenses to place children for adoption and those sorts of things. And Catholic Charities has already been forced to withdraw from providing adoption services in some states as a result of licensing policies that told them, in order to be licensed in our state to provide adoption services, you've got to be willing to place children with same-sex couples on equal terms with opposite-sex couples. And of course, to do that would have violated the religious beliefs of Catholic Charities, and so they chose to withdraw. That's going to become now a nationwide problem, not just a state-by-state problem. And then more generally, religious institutions constantly face the question of can we apply religious criteria in making employment decisions, in deciding whom to hire and whom to promote and all of that. And of course, for churches and religious colleges and other religious institutions that adhere to the traditional definition of marriage, obviously they want to be able to hire people who agree with them about core issues like marriage and the purpose of sexuality and all of those sorts of things. But the Obergefell decision casts into doubt their ability to do that, at least in some circumstances, probably not with respect to federal employment laws, because there's a pretty good religious exemption in federal law, but there are a lot of state employment laws that don't have similar religious exemptions, and so religious organizations in those states are going to face a serious issue of to what extent then can they continue to apply religious criteria.
And Gene? So you list a whole lot of institutions that I see as mediating institutions between government and civil society. So I want to take the conversation out to the broader culture. See if, Ryan, if you could speak on how these institutions are addressed by the decision, because Kennedy does speak about the wider culture. He has his one view, the dissent has another, and these institutions are caught in the middle. So what are your thoughts on the cultural question?
Sure. The cultural question is probably the most important question in the long run. And the central thesis of my new book, Truth Overruled, The Future of Marriage and Religious Freedom, is that the pro-marriage movement is in the same exact situation culturally that the pro-life movement found itself in 42 and a half years ago after Roe v. Wade. That the work that now needs to be done is in 3 steps, and it's the 3 steps that we've kind of divvied up between Carrie, Jean, and myself. The first step is correctly identifying this marriage ruling as judicial activism, just as the pro-life movement did on Roe. We've never accepted Roe v. Wade as the final word about abortion or about the Constitution. In fact, it told a lie about the unborn child, and it told a lie about our Constitution. And for 42 years, we've been bearing witness to that truth. The same thing culturally needs to happen with this Supreme Court ruling. The second point, which Jean spoke to, one of the first things that the pro-life movement did after Roe v. Wade was protect the rights of conscience for all American citizens to never have to pay for abortion or perform an abortion if it violated their beliefs. So in the same way, the pro-marriage movement will now need to protect our rights not to be coerced or discriminated against by the government into violating our belief that marriage is the union of a man and a woman. Step two. Step three is the harder, more difficult, long-term program of bearing witness to the truth about marriage in a legal culture which has told a lie about marriage. Every year on January 22nd, hundreds of thousands of citizens come to the nation's capital for the March for Life to bear witness to the truth about the unborn. In thousands of crisis pregnancy centers across the United States, they've borne this witness. Feminists for Life, Silent No More, Women Speak for Themselves, Collegians for Life, Students for Life. The list of groups that have sprung up in the wake of the Roe v. Wade decision has been remarkable. There's been a concerted effort, cultural effort to bear witness. The question here is, what do we do on the marriage front? Because the reason that the government was in the marriage business in the first place is that marriage actually places a limit on the state. Marriage and civil society limit the government's proper domain. So the state has to recognize the truth about marriage. The state's not free to redefine what marriage is. In the same way that the state has to recognize the truth about our natural rights, including our natural right to life, the state's not free to redefine who has a natural right to life. So we have to kind of remind our fellow citizens of these basic fundamental truths, especially fundamental truths of political philosophy, which Justice Kennedy seems at every step to either ignore or obfuscate. Justice Kennedy, the driving part of his opinion is his philosophy of marriage. And as Carrie mentioned, that has no basis in the Constitution whatsoever, but it didn't come out of thin air. Justice Kennedy's philosophy of marriage is the natural result, the logical result of the past 50 years of the breakdown of the American family. It's the natural, logical conclusion of the sexual revolution. And so it's only a culture that's had the spike in non-marital childbearing, the explosion of no-fault divorce laws now in all 50 states that fundamentally misunderstood the nature of the family and of human sexuality, that 50 years later would even contemplate legally redefining what marriage is, let alone having 5 unelected judges redefine marriage for the entire country. Let me quote a law professor at George Mason University, Helen Alvarez, who went through Kennedy's opinion and has collected all of the words that he used to describe what marriage is. She says, quote, "The Supreme Court rules instead that marriage is about adults, quote, defining and expressing their identity. Adults' desire for, quote, nobility, quote, fulfillment, quote, aspirations, quote, autonomy, quote, self-definition, the avoiding of, quote, loneliness, and desire for, quote, companionship and understanding." Nowhere in that opinion at all is there any discussion about a child's right to a relationship with both a mother and a father. The central defining feature of what got government in the marriage business in the first place, to make sure that men and women commit to each other permanently and exclusively as husband and wife so that children have a mom and a dad, totally ignored in Kennedy's opinion, never seriously engaged any of the arguments that litigators like Jean were making. Jean was the attorney who represented both the state of Utah and the state of Idaho in their marriage cases, didn't engage the amicus briefs that people like me filed, didn't engage at all, just to say in one throwaway paragraph that it's a counterintuitive argument that redefining marriage would have consequences. Whether it's counterintuitive or not, it's true. And the best way to see this is to think what happened after we redefined marriage with no-fault divorce. Marriage had a presumption of being a permanent relationship, and under certain circumstances, you could file for a divorce. In the common law tradition, they would classify them as the 3 A's: abuse, abandonment, and adultery. Serious reasons for saying a relationship that was supposed to be permanent was now being terminated. With no-fault divorce, you could file for divorce for any reason at all. In fact, for no reason. You didn't even have to cite grounds for the divorce, and we saw the divorce rate more than doubled, because ideas have consequences and bad ideas have bad consequences. So what happens now? Take Washington, D.C. The children who live in Georgetown are by and large born into married families and raised to adulthood by their married mothers and fathers. Children in Anacostia aren't as fortunate. They're by and large born to single mothers and have absent fathers. How do we as a culture rebuild a strong marriage culture, insisting that fathers are essential, when Anthony Kennedy has redefined marriage to say that fathers are optional? That's the cultural message that we now have to respond to. In the same way that Roe v. Wade told a lie about the unborn child, that it's a clump of cells, that a woman has a right to choose based upon a privacy right that somehow resulted in a right to choose the death of her child. In the same way, we now have to respond to a bad idea about what marriage is. As Carrie mentioned, what the right to procreation with respect to marriage entails. Is it a right for adults to have children, or is it a right for children to have moms and dads? What direction does this right work in? And so that's what I think the long-term consequence here is. I mean, I think we have to do, number one, call the decision what it is, judicial activism. Number two, protect our rights to live in accordance with the truth. But number three, we have to commit ourselves to a long-term program of rebuilding a truthful, strong marriage culture. And that won't be resolved in the next vote of Congress or in the next election. This will be a generational campaign. Not that the next vote in Congress or the next election doesn't matter. They do. But this is going to be something that our children and grandchildren will be responding to.
So you've mentioned a couple possible responses to the cultural issues, but speaking more broadly and more immediately, what are some of the concrete responses, and I'll open it up to anybody on the panel, that you think can be done near to medium term to respond to this decision to make sure that marriage culture is restored, law is restored, religious liberty is restored?
Well, I'll give one that I think is both medium-term and short-term, medium-term, and long-term, and that is a commitment to nominating and confirming judges who have a principled view of the Constitution and of the law and have demonstrated willingness to stand up for that view when it's challenging and when they're under fire. Because this is something that while obviously this is good, rebuilding the culture is a long-term, multi-generational thing, the next president will likely have 1, 2, maybe 3 Supreme Court nominations. And we saw that last week's decision was a 5-4 decision, a very close decision. This is not the only, and this is not the final decision in this series. We saw a series of decisions leading to this. There was the Lawrence versus Texas decision in 2003. There was the U.S. versus Windsor decision. This won't be the last one in that series. I think it's important to have judges in the court that are going to be faithfully interpreting the Constitution and therefore to make sure that there's a president in place and senators in place who recognize the overarching importance of this issue, because that's whoever is next in the Supreme Court will be there for decades, will have generational impact, has a life term, and we need to make sure our politicians realize this is stakes worth plopping down some political capital on, because all of the other issues they're doing. You look at DOMA, for example, that was overturned. You can have a great Congress and signed by a president, even signed by a bipartisan coalition and signed by a Democratic president, and then later have it undone by a Supreme Court. So whatever you do in all these other fields, the courts ultimately, unfortunately, are going to have the final word on in many ways. Or it's not the final word, but we'll have the final legal word, at least, in our system.
I guess on the religious freedom front, I would add a couple of things that could be done concretely. Number one, I think it's important to continue to press for laws at both the federal and the state level that will protect the religious liberty of believers, both individuals and institutions, from the various obvious problems that the Obergefell decision creates. One of those, of course, is the First Amendment Defense Act, which was proposed recently by Senator Lee and also proposed in the House. I think that law deserves our support because at least at the federal level, it would deal with a number of the issues that we've talked about today, including the tax exemption issue and government contracts and licensing and those sorts of things. But a lot of the problems are going to arise at the state level. And we've seen the challenges of getting state-level religious freedom restoration acts passed, and those would be very helpful if they could get passed. But I think at this point it may be more productive, depending on the state, to get a more narrowly targeted law that just deals with the religious liberty fallout of same-sex marriage. So I could envision a whole lot of miniature First Amendment defense acts getting passed in the states. And of course, short of that, many governors and some attorneys general actually have enough authority that they can forestall or at least mitigate some of the religious freedom problems arising from the decision by an executive order or a memorandum to the people that report to them or whatnot. We saw Governor Jindal in Louisiana do this with an executive order that, for example, protects clerks and other people in Louisiana from having to perform marriages that would conflict with their religion-based conscience. And we saw recently the Attorney General in Texas issue a similar directive to the people who report to him that we're going to protect the religious liberty of the people of Texas wherever we can. So
I have a whole book full of ideas on what we can do at the cultural level. Let me just
available on Amazon right now.
I get a nickel if you purchase it on Amazon. Let me just mention 3, though, in the sake of time, and all 3 will draw parallels from the pro-life movement. The first is we should conduct rigorous social science into family structure. What we know from the past 40 years of social science on family structure is that a child who grows up without a father, whether it's with a single mother, a cohabiting couple, a divorced family, or even divorce and remarriage, all 4 of those family structures produce poorer outcomes for children. We now know this beyond a shadow of a doubt for 40 years of consensus of social science. Why would it now be that being raised by 2 mothers would be the one exception to that rule? So why is it that father absence matters to the child being raised by the single mom, matters to the child being raised by a cohabiting couple, matters to the child being raised in a divorced family, or even divorce and remarriage, doesn't matter to the child being raised by 2 mothers? That's counterintuitive. If Justice Kennedy wants to go there, I suggest that we give the space to social scientists to conduct rigorous, dispassionate investigations into family structures and let the data speak for themselves. In the same way that ultrasound science was our best friend in the pro-life movement, science will be one of our best friends in the marriage movement. The second is we need to find better spokespeople. In the same way that Silent No More, Feminists for Life, Women Speak for Themselves were some of the best spokespersons on the abortion debate, I think some of the children who have been raised by same-sex couples and gay and lesbian people themselves who are against redefining marriage will be some of our best advocates. Both groups filed amicus briefs at the Supreme Court. Neither group was acknowledged by Justice Kennedy. There were very passionate letters written by Heather Barwick, by Katie Faust, both of whom were raised by 2 moms. They love their 2 moms. They still wish they would have had a father. And their argument was that redefining marriage institutionalizes missing parents. That it's not just an accident, it's not just a result of human frailty or weakness, it institutionalizes it. There was also an amicus brief filed by Doug Mainwaring. Doug divorced his wife, came out of the closet as a gay man, realized that he had committed a great injustice to his children because his children didn't need 2 dads, they needed both a mom and a dad. He reconciled with his wife, he's now raising his children together. He makes an argument titled, "I'm gay and I'm against gay marriage." These will be some of the voices that I think will be helpful in the cultural discussion going forward. The third is that science and philosophy are important, but they're not the only thing that's important. I think here, beauty and holiness and goodness actually motivate people more so than philosophers, and I speak this as someone with a PhD in political philosophy. So I think to a certain extent, unless we actually live out the truth about marriage and bear witness to the truth about marriage in our lives, we'll never rebuild a marriage culture. And here it's important to underline the fact that gays and lesbians did not cause the breakdown of the family. Heterosexuals did that. But redefining marriage will not do anything to strengthen the family, but it will likely make the family even weaker. So we have ourselves to blame for the situation in which we are in which marriage has been legally redefined because of 50 years of failing to live out the truth about marriage. And so I would say the third thing is, what did the pro-life movement did in winning hearts and minds? It was setting up the crisis pregnancy centers. It was doing Rachel's Vineyard, Project Rachel, I forget the exact name, but having all these Sisters for Life, all these outreaches to women in crisis pregnancies. We need to have better marriage prep programs. We need to have better programs to help people both understand and live out marriage in their own lives.
Great. So we have time for questions. There will be microphones on either side. Okay. So the event is being broadcast. So I ask that you identify yourselves and any organization you may represent. Keep your questions brief, and please make it end with a question mark. Let's see, right here.
Hi, Penny Starr with CNS News. What about the possibility of term limits for the Supreme Court? Is that something that could happen? There's people that suggest it, and it would certainly open up the idea that we wouldn't have people in that position of power for a whole lifetime. Thank you.
That's certainly something that's been raised before. I think it's really interesting idea. It would be challenging to implement it because I think both sides would be worried about who's president when the term limits start kicking in, whose justices are going to age out first or whatever. But I think if you could get a bipartisan consensus on it, it's definitely something to consider. What would worry me about that, and then there's some other proposals that have been tossed around how we can exert more limitations on justices, is I would worry about anything that emboldens then the president or the senators to say, you know what, we have this backstop here. Well, we have a check on this. We don't have to pay as much attention to really vetting candidates as well because we know they'll only be there for a certain amount of time. Even if there were a term limit, it probably would be a long one, and it would take a while to get it passed. But I think that never can minimize the importance of getting it right the first time and doing everything we can to make sure we have principled judges in place. But it's certainly a thought. It's just not something that's going to happen in the short term. It would require a constitutional amendment even to have it happen.
Over there.
Hi, Darren Guerra, Biola University. Just a quick lamenting that Kennedy actually replaced Bork some years ago, right? Kennedy replaced Bork. It would have been nice to have Bork on the court all the years. But my question is, if children have a fundamental right to a mother and father, could any of you think of some creative legal standing that could create a basis for suit that a child has a right to a mother and father? That, I don't know, just thinking out of the box.
Well, I could see this. Justice Kennedy, several times in his opinion, says that the court's opinion is based on, quote, new insights into marriage. I could see a situation in which the court has a different composition. As Carrie mentioned, chances are the next president will have up to 4 seats to fill. In Inauguration Day, 3 of the justices will be in their 80s, and 1 of them will be 78. So there's a chance that there will be a different composition to the court. And if there are new insights into marriage and new insights into the rights of children, that could be a possibility for the court to reconsider. And I would think the outcome of that would be that we don't know any better than the people, and so let the people decide marriage policy for themselves. So if Mark Regnerus continues doing his social science research, if people like Katie Faust and Heather Barwick and Doug Mainwaring keep speaking out, and if that gets the attention of litigators, gets the attention of justices, there is the potential. This isn't the last word. In the same way that we've seen in the abortion context, having ultrasound, having new insights into the humanity of the unborn has allowed us to have better abortion law. So I wouldn't accept this as the final word.
Thank you. Carl Gollum, I could just preface my question with a brief quote, Galatians 6:7, "Be not deceived, God is not mocked, for whatsoever a man soweth, that shall he also reap." And it seems like the government of this world is sort of strengthened by even sowing chaos, by confusion over the meaning of words that causes us all to look to the government to regulate things even more to make us safe. And it's all kind of a lie. And I wonder if 3 of the great lies of judicial activism, starting with now marriage, but regressing back, looking at abortion, and maybe fundamentally the nature of money, when the Supreme Court began to imply that we don't need to have an honest unit of account. And isn't it even the decisions about credit, IOUs now being money, that fuel the whole power in Washington that much of the country would want to take back? And the states really arguably can, under Article 1, Section 10, disempower Washington and let truth reign in faith.
So essentially, who decides the nature of truth? Is that a good way of recapitulating it?
Well, I think we all have opinions on where the nature of truth really lies, but in our legal system, I think it's best to focus on now some of the practical things that we can do in the short term. Those are theoretical possibilities, but I doubt any of them are going to come to fruition. But what we do know is that in the immediate future, even looking down to the hope of saying this isn't the final word legally, that's a very long-term project. In the short term, there are some real and immediate concerns about religious freedom that I think we need to focus our energy on. Of what are the ways, whether it's through executive orders, whether it's through legal, legislative efforts, to try to bring that back now to allow the room for everyone to have a free understanding of where truth initiates, I guess.
And on that, I would just add that you mentioned redefinition. We're seeing that the Obama administration has redefined the free exercise of religion as freedom to worship. And that has to be something that's not allowed to continue and not allowed to succeed. What the founders intended to protect in our First Amendment was the free exercise of religion, which means the freedom to bear witness to your faith and live out your faith Monday through Sunday, not just Sunday morning in the four walls of your chapel. And we've seen it been reduced. This is why they sued, why the owners of Hobby Lobby had to sue the government, was because they were saying, no, once you go into business, you lose your religious liberty rights. They're even now arguing that once you open up a center to care for the elderly, you lose your religious liberty rights, even if you're an order of nuns. And this is why the Little Sisters of the Poor are still in federal court suing the Obama administration. They're free to pray however they want to when they're in their chapel, but if they want to take care of elderly people, they have to pay for abortion-causing drugs. I mean, that's how ridiculous things are, and that's why, I mean, we can't allow the redefinition of religion and religious liberty to succeed either.
And we can't allow the redefinition of the word exercise to mean just, you can ride a treadmill in your church, but that's the, but that's the extent of your ability to freely exercise your religion.
Over there.
Hi, my name is Jennifer Kirk. I work for the Heritage Foundation. I know this is extreme. I'm just curious what your thoughts are in the concept of completely removing all government, federal, state, local involvement in marriage, all tax benefits, all anything, and allowing it to be purely a religious institution as it was millennia ago.
So I think that would be a bad idea, and the reason why is that, one, I don't think it was ever purely a religious institution. So I would say, I would question the premise of the question. We've seen that political communities have always been recognizing and to a certain extent regulating the marital relationship because it's not purely a private or religious institution. It's not like baptism and bar mitzvah. The state's not in the baptism business, not in the bar mitzvah business, because those really are purely religious, personal institutions. The state's in the marriage business because while your church can marry you, your church can't divorce you, or enforce alimony payments, or child support payments, or settle custody battles. And so you either have the option of the state kind of setting up an institution to do that at the front end, or growing government beyond any imagination by doing each and every one of these cases one by one. So if you get the state out of the marriage business on the front end, you will simply explode the reach of the state on the back end when it's doing a case-by-case basis of regulating these disputes. Much better to have the state recognize an institution in civil society marriage than have the state either redefine it or fail to acknowledge it.
And let me add one point to that, if I may. There are a lot of people in this country who are not religious, and so if you say marriage is only going to be a religious sacrament, we're going to get the government out of it entirely, there will then be no, for a majority of the population, there will then be no institution that is encouraging young heterosexual couples to get married either before or even after they have kids. And so I think that would exacerbate the social problems that we've had with fatherlessness, especially if we said, well, if we said now the government's just going to throw up its hands and get out of the marriage business altogether.
So we got a question from Carolyn Rayburn online emailed in from the Association of Mature American Citizens. Is a constitutional amendment defining marriage as between one man and one woman politically feasible or something worthwhile for advocacy groups to pursue?
It would be wonderful if it could get passed, but it's...
The politics of it, I guess we'll see.
Yeah.
But that at this point, at least with the current makeup of judges, that is what it would take to change things, and so...
Or even an amendment like the proposed Ted Cruz amendment, which would leave the decision to the states. That would also be a big improvement over the status quo.
Again, though, it's a long process getting a constitutional amendment passed, so it's a longer-term strategy.
Back there, way at the back.
I'm Peggy with Faith and Action, and when the decision came down, our phones were flooded with pastors in a panic. Can you kind of really state exactly what happens with pastors? They use the term they're going to have to be forced to marry same-sex couples, or where are they with this, with their licenses to marriage through the church, or whether you're a pastor that works for a nonprofit and you perform marriages?
Well, I think can I answer that? I think the First Amendment quite clearly prevents anyone from forcing a pastor to marry somebody, to marry a couple that he or she doesn't want to marry. So I've never really viewed that as a substantial risk. I think the other risks that we talked about earlier are serious risks, but I think that one is probably not a serious risk.
Alexa Van Ann, I'm a student at Georgetown University. I'm wondering if you guys can speak to this pattern that we've seen with the courts redefining terms. Is there a way that we can stop this from happening in the future in another argument?
Good luck. I think the way we can do that is to get judges who have a very strong commitment to being faithful to the text of the Constitution and the laws. And we notice it particularly in cases like this one where you're going, wow, this is a term they've totally redefined. But unfortunately, this is not a unique case in that sense, because it's a very common problem within the law that either someone will say, this is the standard I'm applying. I'm applying, for example, rational basis, and then they basically redefine it and use it in a different way than it's been defined in every court case previously. So this is really a fundamental problem of judicial philosophy and judicial integrity that we need to address. And we saw it again in the discussion of, is religious exercise going to be redefined? I'll point out again, since judges are sort of my hobby horse, but I really think this is the most important thing we can do for a lot of issues in our culture, that because this decision took place in the courts rather than in the public sphere, it wasn't the kind of thing where we got a give and take and a compromise at the end of, well, how are we going to protect religious freedom? Now, what we have to protect religious freedom is the First Amendment. That is no small thing. However, it is still subject to interpretation by the same judges who are engaging in some of these questionable interpretive linguistic practices. So I think we can never underestimate the importance of the judges.
Final question.
Ron Cruz with Chaplain Alliance for Religious Liberty. There's already been a call by one activist for all chaplains who hold a traditional view of marriage to resign their commission because they're no longer able to support and defend the Constitution as defined by this Supreme Court. But that would apply not only to chaplains, but to all military officers who would hold a traditional view. Is that a concern, that military officers should resign from the military if they hold a view of natural marriage?
On one level, the Constitution doesn't actually say that, so I don't think if the Constitution actually said that, then all 4 dissenters would have to promptly just resign, because they don't think that's actually in the Constitution. They've taken the same oath, so I think that's not something. I hope we don't see a massive exodus of our military members.
And the oath is to the Constitution, not to the Supreme Court's interpretation of it.
And that should be the final word. So, thank you very much, panelists. This concludes our program. Please join us for a lunch in the hall afterwards. Thank you very much.